My time for this speech was fixed at 15 minutes. However, just as with fixed fees, I'm not prepared to cut corners, so forgive me, it will be a little longer. Members of the jury, the profession and vulnerable members of society stand charged by the government of causing an increase in legal aid. They say it is unsustainable in its present form and in need of urgent reform by moving away from hourly rates of pay and introducing price-competitive tendering. If found guilty, vulnerable members of society will be denied access to justice. If found not guilty, the government will need to think again. They may even need to consider bringing the legal aid budget into line with the other two pillars of the welfare state, health and education. You will undoubtedly agree with me the stakes are high. As such, when considering your verdict, you should bear in mind the House of Lords decision of H&R, which decided that the more serious the allegation, the more cogent the evidence needs to be before you can be satisfied that the case has been proved. In delivering this defence speech, I am confident that you will decide unanimously, 1, that the current proposals for legal aid, and which emanate from Lord Carter's review, published in July 2006, is the most damaging piece of work ever to have been commissioned since the introduction of the welfare state. Yeah. And if implemented, it places at serious risk access to justice because there won't be a sustainable and sufficient private practitioner base, and it risks the continued recruitment of newly qualified legal aid lawyers. In a debate in Westminster on the 11th of June, the Legal Aid Minister, Vera Baird, acknowledged there were flaws in Lord Carter's report, accepting that the fees were a cause for concern. That recognition came some 6 months after the report was published. By then, much damage among the morale of the profession, both existing and future, had already been done. As a solicitor, I am also an employer with duties and responsibilities to my staff, my bank who funds me, and the public purse. Competing responsibilities. My difficulty is that the government expects me and my colleagues to function as a private business, but with the aim to make the least amount of profit. Imagine my bank's reaction when I tell them that is my business plan. It's hardly any wonder I've never been taken out to lunch by my bank manager in the last 16 years. It is one thing to have a responsibility to the public purse. It is another thing to have my resources so diminished that I cannot serve my clients properly and treat my staff fairly. Providing a quality service to my clients is intrinsic to what I do. I could not do anything less. I will not do anything less. And if that means I can't provide a service at all, then that will be the inevitable result of these proposals. Forgive me, I know the time is running, but I must take a drink. Returning for a moment to the debate in Westminster on the 11th of January, the Legal Aid Minister said many things which I suggest to you, members of the jury, are not supported by evidence, at least none that has been produced. I remind you that you must decide this case only on the evidence that has been placed before you. You are entitled to come to common sense conclusions based on the evidence, but you are not allowed to speculate, something you may think the government is asking you to do. These are some of the things the Legal Aid Minister said. When referring to family work, the Minister said that 30% of solicitors are currently working within the current fixed fee levels proposed. A little while later in the same debate, and whilst making the same point, she said the percentage was 50%. I suggest that this amounts to a previous inconsistent statement.
There are no excuse for family yet, so I can say any such things.
Minister, the jury isn't allowed to interrupt. And as undoubtedly you will be later directed by the judge, is something you may wish to take into account when considering reliability. If you conclude that this is inconsistency on an important matter, and which I suggest to you it is, you should treat both of the two different accounts with considerable care. In the alternative, I call for full and detailed evidence to support what the Minister said. The Minister questioned why firms should be rewarded for less efficiency. I question her evidence for this also. Lord Carter says his own inquiries have revealed that we have the best legal system in the world. Where is the evidence to suggest that the proposals will penalise inefficiency? What will actually be penalised is efficiency. And the risk is that those firms who are currently performing now to the high standard the public have the right to expect will simply be unable to continue to offer legal aid services. The constant suggestion that legal aid practitioners need to improve standards when those in the profession already know their standard is generally and already first class causes the public to lose confidence in legal aid solicitors. Those of us who recently watched Coronation Street, and I appreciate there goes my street cred, saw that even the Barlows have been persuaded by public opinion to remortgage their house to pay for their daughter's legal representation, not trusting the duty solicitor who was first appointed. If this isn't evidence of the damage that has been done to legal aid solicitors in recent times, I don't know what is. I don't know. What are we lawyers coming to? Coronation Street today, maybe Big Brother tomorrow, or worse still, I'm a legal aid lawyer. Get me out of here. It seems the government's view of solicitors is beginning to influence the public. Well, let me tell you this. The government has got something right. Solicitors are revolting. Revolting against the implementation of ill-thought-through and unworkable legal aid proposals. The Legal Aid Minister suggested that other countries such as France and Germany spend far less money on legal aid per head per taxpayer. However, I question the relevance of such evidence when the legal systems are clearly not comparable. Both systems operate under a codified Roman law system, which is completely at odds with Anglo-Saxon common law, which are uniquely flexible. I also suggest that there are many other factors that need to be taken into consideration before suggesting this is remotely relevant, such as the size and type of society each country has. I call for evidence before this statement can be considered at all relevant. There are many more statements of fact advanced by the Minister with which I take issue. I refer you to Exhibit Number 1, Hansard's publication of the debate, and urge you to read that debate when deliberating. I am in no doubt you will come to the same conclusion as I, which is that without evidence to support each fact asserted, little weight could or should be attached to what the Minister has said. Members of the jury, when you retire to consider your verdict, I would like you to consider a number of questions in which I will summarise as why, what and how. Firstly, why? Why is it necessary to reform legal aid in the way proposed by Lord Carter? In brief, the government says this is because the cost of the legal aid budget is rising. However, I don't need to remind you that the annual increases in the health and education budgets are many times the entire legal aid budget. In Westminster on the 11th of January, Simon Hughes MP asked the Minister to examine what would have happened to the pay of the local teacher and the local general practitioner relative to the pay of the legal aid solicitor since Labour came to power. He said, and I quote, "The answer is that the legal aid solicitor will have done worse of the